Okay, so thank you very much for this chance to present our work. I have to say that I am the presenter, but the work has been prepared by all the team. We decided to divide the presentation in 3 parts. The first one is a kind of summary of how the seminars were and the results. Then an overview of the procedures following the scheme prepared by the Hannover team. And then I will refer to some specific issues that were more interesting, taking into account the questions in the seminars and the webinars. The first webinars took place in December 2020 and February 2021. The dissemination was all the members participated in them, and we have here a problem because the institutional communication. Okay, we send the information to different professional groups, but the truth is that the institutional websites or the representatives of the institutional bodies just were a bit reluctant to send it, not them to send them, but to promote it. So we have the impression that the dissemination could have been greater if the channel would have been different. A second issue is that Spanish is divided, as you probably know, into autonomous communities. So the professionals, lawyers, attorneys, and so on, are organized at community level, at the autonomous community level. So perhaps the greater interest goes to the activities organized by the autonomous community. Anyway. As the first and the second webinar were online, this is something we could, something interesting to achieve a greater number of attendance. Regarding the attendance, in the first webinar, we limited the attendance to 50 participants as the number of participants were overwhelming. We opened it until 75, but we have many more petitions for registration. So even though in the first webinar many people could follow it through a YouTube channel, they could not participate. And then in the second webinar, we open the registration until 1070. We admit some more people, but of course it was much more successful because of this reason. Regarding the attendance, the majority were attorneys. We think that the main reason is that they are the ones that have to deal with these procedures on a daily basis, and they have perhaps less resources to know about these procedures. Regarding the judges and lawyers, as we realized that they were less interested as we thought initially. I mentioned some problems with the dissemination of the information, but all we have to do is guessing the hypothetical reasons to have less judges and lawyers than attorneys. Perhaps it is because they have many more resources for formation. Perhaps they think it is too much formation for such a procedure that, as we will see, it's not such a big issue here in Spain. But only we can guess. We do not have the real reasons. And about the contents and development, the feedback was overwhelmingly positive. It was a big, I think it was a good thing that we have experts as keynote speakers. They could, specifically, we have a person that have both profiles. He was a former judge and now he's dealing with the government of the judges. So we have both approaches in a single presentation. So we invited him again, and it was very successful. Most of the, cost. Perhaps the feedback was not so good in the sense that they should have the materials in advance in the first seminar. So in the second seminar, we spread the materials before the beginning of the seminar, so they could just check it before and so on. And to say something not so positive, they asked for more time to questions, but you know, and also for interactivity. But this is something that is not only, that's not only dependent on the organization, but on the time that the speakers take to for their presentations. About the seminar we have here in October 2021, well, we have here several things that convey in these days. We have a new COVID alert, so I think it may influence perhaps in the low we have less attendance. Of course, being in presence and not online was the target number was only the autonomous community. And we have here the thing that several students applied for register because they were interested. We just allow some of them, but it was where in the students field where this seminar raised more interest. Even though the feedback was positive, we think that a big a difficulty, in fact, was that it was conducted completely in English, and the commanding English is not so widespread in some of the juridical professions, like attorneys. So we think that it may have influenced the diminishing the attendance in this seminar in October. Anyway, it was most of the attendance were happy with the seminar. So let's go to have an overview of the main features of the European Order of Payment Procedure. I just put them in the same slide, so you can, even though I'm going to do some comments. Here you can have an approach about this procedure. The competent court is the first instance court, it's the lower court. The estimated cost is 100 euros plus a percentage of the quantity. This percentage varies depending on the amount of the quantity, but this cost is besides the regular cost of a procedure. I will refer to the expenses further, but you will see that this is something that is an issue right now related to this procedure. Regarding the national service measures, telematic measures are allowed, and usually they should be it should be done within 1 month. About the duration of for the issuance of the European Order of Payment procedure, there is not a stated maximum. It depends on the workload of the court, the parties' attitude, and other elements. I'm not referring for length to these issues because they have been treated in the webinars and in the seminars. So if anybody wants to check it, as they will be available, you will have a development of every one of these items. I'm just doing an overview. So the requirements, this is it has to be noted that not bail is needed. And regarding the national procedure, there is a similar procedure. It's called Proceso Monitorio in Spain, but there are some reasons that would justify a preference for the European Order of Payment procedure. Well, first of all, the first one will be avoiding the examination of possible abusive clauses contained in the contracts on which the debt being claimed is based. Another one is avoiding the submission to the proceedings of evidence proving the very existence of the claim. Besides, the Spanish law on procedure, or civil procedure, obliges the Spanish order for payment procedure the control of possible abusive clauses. So in the European Order of Payment Procedure, it is not possible to carry out such a control of unfairness they are not documents. So the current regulation does not allow the national judge to request any kind of clarification or to demand the documents. The consumer cannot properly formulate the opposition as he does not know if the amount claimed is enforceable and if the terms are unfair. Regarding the European small claims procedure, this case is much more simple. What I'm going to refer to, it's the estimated costs. There are no taxes for this procedure, and the expenses depending on the plaintiff decisions. As we explained in the webinar we have this month, the decisions of the plaintiffs are very decisive in this case. For example, you are not obliged to have a lawyer, but if you decide to have a lawyer, you have to pay the fees, and this makes a difference in the cost of the procedure. And sometimes these costs are not avoidable. If the language is different, probably a lawyer, an expert lawyer, should be needed to deal with this issue. Regarding the counterclaim, it is possible to, if the claim and the counterclaim are connected. It is not possible if the counterclaim exceeds the scope of the small claims procedure. About the remedies, there is no appeal if the amount is less than 3,000 euros. From 3,000 to 5,000 euros, it's possible the appeal to the same court that will accept it and set it to the higher court. Now, as I said, I'm going to refer to three specific issues related to these procedures. First of all, regarding the expenses. If we I have to say that this is a brief reference to the issues that have been discussed during the webinars. Regarding the expenses, the first of the items, if we intend to arbitrate the means that can also be used for minor consumer claims, the solution necessarily involves that the claims should not entail a lawyer's fee and that the consumer is informed at all times about the potential positive or negative consequences of his claim. For example, it is important for the parties if they cannot be ordered to pay costs or to know whether the other party can counterclaim or not, whether they will be able to withdraw from the process at any given moment, and so on. The regulation establishes that costs must be reduced and the details and means of setting those costs must be transparent. However, the member states do not always try to comply with, or they try but do not get it to comply with this wish of the regulation. And I'm saying wish because it cannot be called any other name, since it is contained in the recital of the regulation and not in the articles. So Article 16 of the regulation lists down the rules for the awarding of the costs in the proceedings, but it does not require any contention in this respect. The importance of achieving a process that is not excessively costly for the parties was highlighted by the reform of the regulation of 2015, where the text that in the 2007 regulation was part of the preamble of the regulation became part of this new one in Article 15A. But despite the legislator's intention to keep the costs of the proceeding within reasonable terms, Article 15A does not go so far as to establish a mandatory rule. In fact, this is understandable because the legal traditions and the per capita income of each member state requires different rules. Article 15A only imposes the obligation to establish forms of payment that facilitate the payment of costs to the litigants, such as through a credit card or through a bank transfer. Well, as I said, it is not easy to keep the costs of the process within low limits, considering that the small claims procedure is a relatively unfamiliar process for lawyers, and that it has an international element that can make lawyers' services more expensive. Regarding the available procedures, the several procedures available in Spain, the small claims procedure and the European Order for Payment procedure have often been object of study, in spite that they are not very well known among citizens, and statistics about its use in Spain show very low figures. However, this situation is not specific to Spanish law, not just in this country. In most member states, there are processes for debt recovery, as we have seen in the previous presentations, that follow a similar technique to the small claims procedure, and these are generally being used frequently. Just to give you some figures of our country, in Spain in 2018, there were 2,250,000 civil claims and only 500,000 domestic small claims procedure. That is 20% of the civil claims were domestic small claims procedure. The figures were similar in 2019 and 2020, even though in the 2020 there was a slight decrease due to the lockdown and the interruption of the activity of the courts. Well, the reason for these numbers in the size of the Spanish small claims procedure is that it's a very effective process when there is a debt insolvency of the debtor. In these cases, opposition is very unusual because the debtor does not actually disagree with the claim, but he has no means to afford the payment of the debt. Any opposition in the event of insolvency would only serve to lengthen the process and make it more costly. Thus, increasing the debtor's own debt is an unavoidable result. Even if the creditor knows that he will not be able to collect the debt due to the debtor's lack of economic capacity, the process serves to easily obtain an enforceable title that can be very useful when the debtor improves his economic situation. As it happens in domestic law, all these characteristics of the European small claims procedure should lead us to believe that this is a process that should be a great success and should be widely known and used by companies and individuals. But this is not the case at all. Far from that, the small claims procedure is very little used and very little known in the country. For example, in Spain, there are two processes: an ordinary process and a special process, similar to the small claims procedure, that are optional for the claimant. The advantage of this situation is obvious. The litigant, the plaintiff, can choose the most suitable procedure for him, taking into account economic criteria. For example, the duration of the process, the rules of competence, or any other feature of the regulation. Despite what a first impression might indicate, the possibility to choose among various means of debt recovery is not confusing, as the difference between them are quite clear. The difficulty for the claimant or plaintiff may rather come from the fact that all existing procedural remedies are very similar, so that it can be somewhat confusing for a citizen that is not familiar with the law to discern which is more convenient. But at the same time, apparently an important rule can make a big difference for a citizen. So just as an example, let's think the difference between having the possibility of holding the proceeding in his own domicile or in his own language, or have to hold it abroad. Furthermore, it's striking that despite the existence of different processes, the different processes for claims, the claims for very small amounts of money are not well protected, because none of the European means is effective in protecting claims of very small amounts, let's say 50 or 100 euros. The fact that there are different means for claiming debts can easily lead to false lease pendants, as we saw in one of the seminars, with several cases where the parties initiate similar processes, and where there are obvious connection of the object. And finally, regarding the possibility of appeal, Article 25 of the Regulation of 2007, A1 A61 in 2007 includes among the information that member states shall communicate to the Commission the availability of an appeal under domestic law. That availability of the appeal has been an issue under Spanish regulation. When the regulation was approved, Spain reported that an appeal could be lodged against judgments rendered in small claims procedure. This possibility corresponded to the general rule under Spanish law whereby judgments involving claims of that amount could be appealed. However, years later, that possibility of appealing in Spain for civil claims for an amount of less than 3,000 euros was repealed. This reform, subsequent to the information provided was subsequent to the information provided to the Commission according to Article 25 of the regulation. But it could give rise to doubts as to whether the possibility of appeal was maintained or not. But the legislator clarified this possibility in the law itself. The decision issued in a small claims procedure are exempted. When the issues seem to be resolved, Spain has informed the Commission in 2016 that the judgments issued in a small claims procedure may not be appealed. The only possibility to challenge the judgment is through review of judgment. This change by the legislator is difficult to understand because it restricts the rights of litigants in Spain in relation to the guarantees existing in domestic laws. Thank you very much.